Do you know of a stellar leader or an outstanding organization that deserves a proper shout-out? Nominate them for IBJ's awards. From 40 in their 40s and Women of Influence to Nonprofit and Healthcare Excellence Awards, we're celebrating rising stars, seasoned leaders, and organizations making a difference. Discover which programs are accepting nominations now at ibj.com/nominate.
Welcome to the Indiana Lawyer Podcast. I'm your host, Maura Johnson, and today we're going to get a little spooky, but not too spooky. In this episode, I'm joined by personal injury attorney Tim Devereux to talk about safety and legal protections surrounding haunted house operations. Devereux is a partner with Wagner Reese, LLP, which has offices across Indiana and Illinois. He's been in the practice for over 37 years, representing clients in personal injury cases across the board, and has firsthand experience with haunted house cases. He joins me to talk about what cases plaintiffs bring against these attractions, how companies protect themselves from legal action, and how the experiences have evolved in the last few years. But before we jump into the episode, let's hear from our sponsor, Taft.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
So to start out, one thing that you mentioned when I had first pitched this episode idea to you was just how much the haunted house experience and these attractions have evolved over the past few years. Can you delve into that a little bit?
Sure. Many years ago, most of the haunted houses were done by local groups, Boy Scouts or nonprofit groups, and they were done as fundraisers. What we've seen in the last 20 to 25 years is it's been almost the industrialization of the Halloween haunted house. They are now becoming larger, more involved, using more complex special effects. Some of them have now permanent facilities that even though they're only used during Halloween, the actual physical facilities year round. Mm-hmm. And as I think I was mentioning a little bit earlier, Universal had so much success with their Halloween Horror Nights at their theme parks, they've now opened up a permanent exhibit in Las Vegas called, I think it's Horror Nights, and it's going to be a permanent year-round Halloween-type horror show. That's
so interesting. Just like you said, the industrialization and just the commercialization, I guess, too, of Halloween as a holiday. So what's your experience in the world of haunted houses and representing clients in these cases?
I am an attorney that represents people that are injured. Mm-hmm. This is called a plaintiff's personal injury. I've been practicing for 37 years. I've handled cases all over the country. I have looked at multiple cases involving people that were injured at these types of haunted houses. And for reasons we'll discuss in a little while, you'll see that these cases are very difficult to proceed with. But throughout my practice, I have dealt with a lot of businesses, not only haunted houses, but other businesses that use what are called waivers or releases. Mm-hmm. And that is a major factor in whether or not you can bring a claim if you're injured.
Yeah. So let's get into the waivers of it all. I guess can you just break down what's typical in these waivers? What do they specify, and how does that interact with your job, I guess?
Sure. Indiana allows businesses to use waivers or releases. There are a number of rules that govern how you can use them and when. Typically, you can use a waiver in a contract when the activity is recreational or it's elective. It's something the person doesn't have to do. If it is something that is mandatory, the courts call that a contract of adhesion. And if you have something like you need utilities for your home, you need water, that's a contract. You don't have a choice. You have to enter into that. So they don't typically allow these type of releases in those instances. But when it is a purely recreational activity, like a haunted house, like attending a stock car race or riding horses, things like that is something that it's your choice to do. And they can impose a release, and that release protects them from being held liable if you get hurt.
Mm-hmm. What is the specific language of these waivers? I know that you highlighted a little bit of
I did grab one, and this is one from a haunted house here in the area, mm-hmm. And it includes such things as disclosure of risks. Haunted Halloween house activities are very extreme activities, are very high risk, and possess an elevated level of danger that could result in physical and emotional injury, permanent injuries, death, and property loss or damage. And then they go on to basically say, if you get hurt here, you're assuming the risk. We warned you that you could get hurt, and you are agreeing that you will not attempt to hold us liable for any injuries that you might suffer as a result of participating in this event.
Something that I was mulling over just talking with people about my distaste for haunted houses as a experience for myself is the idea of maybe mental distress. Is there anything, I guess, legal in that? I know some people could maybe argue that. What is the language around that?
There isn't any because you're going in there knowing you're going to get scared.
Yeah.
And you cannot sue because you got too scared.
Yeah.
Basically.
Right.
You can have fun, but it's not a basis for a lawsuit to come in and say, you scared me worse than I thought.
Yeah.
That doesn't mean that there are no limitations because these types of releases typically cover what's called negligence. And negligence in the law is simply failure to use reasonable care. There are certain conduct that you cannot waive. These releases do not protect a company when there is gross negligence, recklessness, or willful and wanton conduct. So if the conduct is egregious, then it goes beyond mere negligence and you cannot protect yourself from liability with a release in that instance. An example I saw of one is if you're in a haunted house, they can jump out at you, they can scare you, that's fine. They can't lock you in a room. That was an example I had seen where if you went into a room and they locked you in the room, or if a staff member pinned you to the ground, something like that. It has to be more than just what you would expect. Someone jumping out at you, they might make incidental contact. The releases specifically talk about that. The releases also not only protect the business, it protects the employees of the business. So any staff members there that might happen to have physical contact with you are going to be protected under the release unless their conduct is extreme.
Right. And something that I've kind of, I guess, maybe seen because of the more popularity of these growing is the differences in haunted houses that the actors just jump out and spook you. And then there are some where they can touch you, they can interact. What have you seen in terms of the waivers? Have you seen any differences between those two?
Not really. The waivers are pretty much a blank general waiver. And a lot of times, keep in mind that a company will write a waiver that is even more broad than the law will allow. You know, just because the law says you can't have this language in there, or just because that language might not be enforceable, doesn't mean they don't include it. Okay. So in a lot of the releases, we'll see language that says, hey, if we touch you, if you are contacted by a staff member, that's still covered under the release.
Okay, interesting. And I know there's a lot of these houses that are commercialized, like a lot of places in Indy, but are also maybe not as their people's backyards or their haunted mazes, or what is, I guess, maybe the limitations and whatnot around those types of places?
Sure. Most places that operate where they're going to charge someone to come in to a haunted maze, a corn maze, whatever, that is a business enterprise, which means they have to have insurance. And it's the insurance companies many times that will say, we're not going to write the policy unless there's a release there that limits our liability. So I'm not aware of any haunted houses or corn mazes that I've come across that don't use a release of some sort or another. They can be specific, but they require you to sign. Some of them are built into a ticket price. It'll just say, by purchasing these tickets, we hereby agree to the terms and conditions. If you go look up the terms and conditions, that language is in there.
Yeah.
I can't think of a single instance in the last 10 years where an enterprise like this didn't have some type of written release. Also, if you go into these places and, you know, any of the readers that do go to these places, their signs all up, all over saying, you know, you enter at your own risk. You're going to be scared. We are going to jump out at you. There are going to be shocking moments, strobe lights, things like that. So they do a pretty good job of warning people, this is what you're getting into. Be aware.
Yeah. Absolutely. I was going to say, that's making me think of several years ago, I went into, I think it was a corn maze, and I don't think it was haunted, but I definitely had to sign a waiver. Maybe just to get lost. I don't know.
To walk around a cornfield.
Yeah.
Exactly.
Just in case.
Exactly.
So I know that you talked about, specifically in Indiana, but obviously you can practice in other states. Have you seen, what's your experience in other states? What are kind of the differences, maybe, if any?
The enforceability of waivers varies from state to state, but by and large, they all typically follow the concept that if it is a recreational activity, it's not something you have to do, you are electing to do it, you're choosing to engage in this activity, then the business performing that service can put limitations on their liability. And that, if a person were to get injured in a haunted house, the written release and the written waiver is only the first line of defense for the business, because even if you're able to get around the release for some reason, they still have the ability to raise multiple defenses. And if a person gets injured in a corn maze or at a haunted house, that's what's called premises liability, because you're on someone's premises and the basis for the liability is the premise. When you go onto a premise, there are different classifications. Most people going to a haunted house are considered business invitees. You're there to buy their service and benefit them. So that's considered an invitee. In that instance, a landowner owes you a reasonable duty of care to protect you from conditions that they know of or could have discovered under the exercise of reasonable care. There's another category called a licensee, and a licensee can be, say, someone from the utility company needs to come onto the property to check a water meter. They're there for their own benefit, for the benefit of their employer. So in that instance, the licensee is owed a lower level of care, so to speak. And then the final classification is a trespasser. Oh. And if a person's a trespasser, it basically says they don't owe you any duty, but they cannot intentionally harm you. They can't set up trap guns or things like that. If you qualify as a business invitee and you can get around a release, then the defendant or the haunted house operator can raise multiple defenses. The first one's going to be assumption of the risk. You assumed the risk going into this, you knew about it, and we warned you about it. There's also a thing in Indiana law called comparative fault. And that means when a jury goes to decide who's at fault for an injury, they assign a percentage of fault to everyone involved. So in an instance like this, when you chose to go into the haunted house, you're the one that encountered the scary instances, and say you got scared and you started to run and fell. They're going to say that's your fault. You're the one who caused yourself to fall. So they have multiple defenses that they can raise. So it's, and even, and it gets even more complicated than that, because if you can get around the release and you can find a basis to bring a lawsuit against them based on the business invitee, these companies are very sophisticated. They typically form and are operated by LLCs, a limited liability corporation, which means exactly what it says, limited liability. Their liability can be capped up to a certain level. Yeah. So it's a very difficult road for an injured person to pursue to be successful in bringing a claim against a haunted house like this.
Absolutely. Another kind of question that I just thought of is, you mentioned obviously interactions with employees. Is there ever any case where it's like faulty decorations that fall, or like whatever? What is, I guess, kind of maybe the roadmap for something like that?
It's all covered in the releases. Yeah. It even says you're going to run into conditions that are both man-made and artificial. Things can go wrong. Our safety equipment may not work. You are accepting that risk. Yeah. So it's all built in. These releases are very thorough, and they're more common than you think. I was joking a little bit to myself as I was driving down here, because I saw a person on one of these rented bird scooters. Yeah. To rent the scooter, you have to check a box. And when you check that box, that contains a release like this. Yeah. So I have had many, many cases where people got hurt at a haunted house, or rock climbing at one of these facilities in town, or they've rented a scooter. And first thing we ask them is, did you sign a release? And many times the person who's injured doesn't even realize that release was buried down in there.
Yeah.
And some of them are I don't want to say tricky. They are well thought out, and they are, have a lot of foresight, because they say, even if the release doesn't bar you and you can sue us, you hereby agree to liquidated damages in the amount of a nominal amount, like $100.
Yeah.
So it's like, look, okay, worst case scenario, you beat the release, you prove we were negligent, you get around any type of insurance exclusions, most you can hold us liable for is $100.
Yeah.
They have protected themselves on multiple fronts.
I was going to say, it's definitely a very well built, and that's probably why when I was looking for this, I wasn't seeing a lot of suits.
And that's exactly why.
Yeah.
These businesses have gotten very sophisticated, because this is not the nonprofit, although we're going to make some money as a fundraiser.
Yeah.
These places have entrance fees of 10, 15, 20 more, and they have very good lawyers. They have contracts. They're well set up to protect themselves in the event someone gets injured.
Yeah. Well, yeah, and they're proper. I mean, I think we keep going back to Universal Studios as a very good example of just a well-rounded, it's built into the ticket, you said. It's covered on all bases.
And they're aware of it. These companies know that people are going to get hurt at one point or another through either no fault of their own or through fault of someone else. And they have anticipated this, and they have drafted their contracts to protect themselves in the event that someone does get hurt.
Yeah. Last question I have. This episode's coming out right around Halloween, so I have to ask, any favorite Halloween traditions, movies? Are you a horror fan? No?
Yes, I am. We enjoy horror movies.
Yeah.
I like the ones that are more thought-provoking and makes you more mental than jump scares.
Yeah.
The Changeling with George C. Scott. That goes way back in the 80s. It was great. It's all about a haunted house.
Okay.
There's no murders, there's no gore, there's no guts. It's just a good, scary Halloween story.
Interesting.
But I decorate. My wife and I go overboard. Actually, it's rubbed off my kids decorate now.
I love it.
So where people tease me, I'm that guy in the neighborhood. He's got his house decorated. And on Halloween, I'll have a flaming pumpkin with 3-foot flames coming out of the pumpkin.
Have you ever considered doing a haunted house yourself?
Only with a release.
Absolutely. I agree. Do you do full-size candy bars?
Occasionally.
Okay.
We do. We typically do baskets for the little kids that we know in the neighborhood. They're going to come around. But for years, we did trick or beers for the dads.
Oh.
So the kids get candy, the dads get a beer, and made for a fun Halloween night.
Yeah. I will say, there was one Halloween that I was trick-or-treating, and somebody was dressed up as like a horrifying creature sitting on the porch, and they jumped scared and chased me down the driveway. And I think my statute of limitations has come up or has ended, and I can't sue them anymore, but
probably
kind of wish I could, because that was traumatizing.
Yeah. I don't do that anymore. As a kid, we used to do that, but I don't want to scare the little ones.
No. All right. Well, thank you, Mr. Devereux, for joining me. I appreciate it.
My pleasure.
Thank you for listening to the Indiana Lawyer Podcast. If you'd like to stay up to date on legal stories happening across the state, you can check out our website at theindianalawyer.com. While you're there, you can subscribe to our newsletters, find more podcast episodes, and listen to podcasts from across the IBJ Media Company. And if you're on social media, you can follow us on Facebook, Twitter, Instagram, and LinkedIn.
Do you want the real scoop on what's happening in Indiana business? Check out the IBJ podcast. I'm Mason King, and each week I sit down with people who make news in Indiana to get insights and perspectives you won't hear anywhere else. It's business, but you won't need an MBA. The guests run the gamut from CEOs, developers, and sports executives to artists and chefs and financial planners. If there's a theme, it's that everything has a cost. And success often depends on how you define profit and loss. So if you want to deepen your understanding of the people and projects shaping Indiana, give the IBJ podcast a try. You can find it at ibjpodcast.com or wherever you get your podcasts.
On the go? So are we. Get the IBJ Media app, your all-in-one news source for Indiana business news. Get breaking news alerts, read every story from IBJ, Inside Indiana Business, and the Indiana Lawyer, and listen to your favorite podcasts all in one place. Big news, small screen. Search IBJ Media and download the app today.